Robinson versus Lynch. My name is Judge Evelyn First. Could I have the parties please put their appearances on the record?
Jared Bennett on behalf of the United States, and with me at council table is Matthew Glover, who will be arguing on behalf of the United States today.
Okay, thank you.
Harold Robinson, Your Honor, pro se.
Thank you. All right, and we are here today on the government's motion to dismiss. So, Mr. Glover, if I could hear first from you, please.
Good afternoon, Your Honor. Matthew Glover on behalf of defendants, the United States. In this action, Mr. Robinson claims that 18 U.S.C. 22G1's prohibition on purchasing or possessing firearms violates his substantive due process rights to self-defense and personal safety and security. This court should dismiss because under Graham versus Connor and its progeny, where a particular amendment provides an explicit textual source of constitutional protection against a particular government action, that amendment and not the substantive due process clause is the appropriate grounds to bring. Now, Mr. Robinson's constitutional rights that he seeks to vindicate, both self-defense and personal security, are at their core the right to possess a firearm in furtherance of those, and that is the Second Amendment right. In Albright, the Supreme Court was confronted with a 14th Amendment seizure that was brought under substantive due process and, in essence, was challenging the unlawful seizure. And the court held that the plaintiff couldn't rely on the protections of the substantive due process clause, but needed to bring that under the Fourth Amendment. Here, whatever the merits of Mr. Robinson's claims are, again, at its core, they are Second Amendment claims, and he's to bring them there. He has explicitly disavowed Second Amendment claims, both in not pleading them in the Second Amended complaint and in his opposition to our motion to dismiss. I'm happy to discuss some of the cases cited in our brief dealing with other courts rejecting substantive due process challenges and conferring them under the Second Amendment. I'm also happy to discuss Albright cases or any of the other points in our brief, if it would.
I guess my question to you would be, I understand the government's position that the recent Supreme Court case law has made clear that the right to self-defense is a Second Amendment right. But as Mr. Robinson argues it as a Fifth Amendment right, I guess my thought is procedurally, I'm bound by the Supreme Court's finding on that it's part of the Second Amendment and that it's not to be considered under the 14th Amendment. Would you agree with that?
Yes, Your Honor.
Okay, so then from that perspective, if Mr. Robinson wants to continue to pursue that, no, this is actually a separate right under the 14th Amendment, his avenue to do that is through appeal of a ruling by this court following the Supreme Court. And he would have to appeal up to the Supreme Court for them to reconsider that issue.
Yes, Your Honor, and I think that follows directly from the Supreme Court's admonishment to lower courts in Glucksburg not to expand the substantive due process right without being thorough and examining and waiting for direction from the Supreme Court.
Okay. And I guess why don't you go ahead then and address Albright to the extent that you think that we should consider that.
Yeah, in response to, Mr. Robinson raises in his opposition that you're looking for a particular constitutional text, and he's asserting a right to self-defense, and the Second Amendment talks about bearing arms, and he's also asserting a right to safety and security. But again, if you look at the language from Albright at 510 U.S. 273, the court talks about explicit textual source of constitutional protection against a particular sort of government behavior. And so the particular sort of government behavior at issue here is prohibiting firearms dealers from selling to Mr. Robinson, or were he to possess a firearm, then potentially prosecuting him, basically barring him from possession of a firearm. The barring from possession of a firearm is what's at the core of the Second Amendment. Some of the cases to have dealt with Albright In the 10th Circuit, one I guess I might draw your attention to is Travis versus Park City Municipal Corp., which is 565 F. 3rd at 1252. It's a 2009 10th Circuit opinion where an artist in nearby Park City was seeking to display and sell his art, I believe in advance of the Sundance Festival. He was stopped by the municipality, which required, I think, some sort of a license or a permit, in order to display your art. And they explained to him he wouldn't be able to get one in advance of Sundance. He went out and displayed it again. He was cited. He challenged the citation under the First Amendment, his free speech rights, the Fourth Amendment, and equal protection and substantive due process. And the court, when they got to his substantive due process challenge, said, no, what you're asserting is a First Amendment right to either display your art, or you're asserting equal protection that others who have gotten this licensing, the license scheme, somehow is discriminating against you as an individual artist. So again, you had substantive due process on a behavior that is at the core in some sense of the First Amendment, but describes a panoply of government behavior, and they looked at what the government was doing in preventing him from displaying his art and citing him for doing so, and found that other constitutional rights were more appropriate. The cases cited in our brief involve Second Amendment claims where courts have said, no, you should have brought this, or you added on a substantive due process, or in one case, the First Circuit case, they asserted only equal protection and substantive due process claims, and the court said, no, these are properly viewed under the Second Amendment. I don't know if you had any questions about the specifics of those, or...
I don't think so at this time. I guess another question I had based on the briefing, in your initial brief, you addressed the issue of why Mr. Robinson is a person who the statute was designed to prevent having a gun in the future. And then in Mr. Robinson's opposition, he makes clear that he does not intend to bring a Second Amendment complaint. And so does that then, from that perspective, and then in your reply you don't bring that issue up again, so from your perspective, that issue is not, that would only come up if we were arguing Second Amendment?
Yes, Your Honor.
Okay.
It's our position that he has affirmatively waived any Second Amendment claim, and even given the solicitude to do a pro se filing, in his filings after the complaint in response to this motion, he's made clear that that's his position. So we don't think you need to reach the Second Amendment merits of it because they haven't been raised, or they're not presently in the case.
Okay. And then should I take any significance from, or should I be at all concerned or distinguishing with the fact that some of the language about the right to self-defense in the most recent decision from the Supreme Court is in the plurality as opposed to the majority portions of that opinion?
No, we don't think that makes a difference, Your Honor, because, again, the government action here is preventing him from possessing a firearm, and in this as-applied challenge, 922G1 is functioning to prevent him from possessing a firearm in the home, outside the home, and so, again, he's still at the core of the Second Amendment right, or maybe not at the very center if he's seeking to possess outside the home, but he's still within the panoply of the Second Amendment right, and the government's action is still related to preventing him from possessing firearms.
Okay. All right. Anything else you want to address?
And not unless there's anything you'd like me to address, Your Honor.
I think that's good.
Thank you.
For now. Thank you. And Mr. Robinson.
Your Honor, the Supreme Court in the District of Columbia versus Heller explicitly stated what the founders' intentions of ratifying the Second Amendment was, and that was to preserve a well-regulated militia. Though the Supreme Court stated that the right to keep and bear arms is a core component of the right secured by the Second Amendment, it explicitly stated also that the right to keep and bear arms for self-defense and hunting was not included in the, it was not included in the founders' intentions of ratifying the Second Amendment. Under that, the government's argument doesn't comply with the Albright versus Oliver more specific rule. The rights that I'm seeking to vindicate are indeed unenumerated rights. They're unenumerated fundamental rights, both of them. In fact, Ingram versus Wright explicitly states that personal safety and security is an unenumerated historical liberty interest that I have a right in. It is a substantive due process claim. And indeed, the government hasn't even asserted that the Second Amendment is the explicit textual source. Well, actually, it has. Excuse me. It has it in the government's reply, original motion. It asserted that it was actually in its reply that it was the excuse me, I forgot. Just a sec. The government asserted that the right to keep and bear arms, or that the Second Amendment is the explicit textual source for all armed self-defense. And also in Heller, the majority of the court explained that that's not true. They explained that the founders thought it even more important for the right to keep and bear arms even more important for self-defense and hunting. So my interpretation of Heller is that they're intentionally separating the right to keep and bear arms for self-defense and hunting versus the right to keep and bear arms to maintain a well-regulated militia, the citizens' militia.
So that part of the Heller opinion, they are talking about them separately, but aren't they saying that? I mean, aren't they saying that even more important than the right to militia is the right to self-defense?
Yes, but that wasn't the explicit reason that the founders ratified the Second Amendment.
But wasn't that part of the explicit reason that the Supreme Court went forward as it did in Heller to say what they did about the right to restrict the personal use of arms or personal ownership of arms?
I'm not following your question, Your Honor.
Okay, so I understand what you're saying. You're making an argument about why the founders did what they did as far as ratifying the Constitution. But from my perspective as a lower court, I'm bound by what the Supreme Court's current jurisprudence, current position is on this. And it seemed to me that in reading Heller that their position is that the Second Amendment is not just about militia, that it is also, and more importantly, about the right to self-defense. And so even if, even taking what you're saying as true, that the founders may have passed it based on it being a militia, if the Supreme Court is saying it's based on self-defense, doesn't that then foreclose me as a lower court from reaching out to the substantive due process clause? Because the Supreme Court has said, no, the right to self-defense is incorporated, is part of the Second Amendment.
Well, they said that the right to keep and bear arms, that's not all that is entailed, that there is a facet in the Second Amendment that does. My understanding of it is that the Second Amendment does not prohibit you from using the arms that you would use for your militia service for private purposes, for self-defense and hunting. In fact, I'm sorry, Your Honor, I actually wasn't prepared to discuss all this. I thought we were just discussing what was actually in our filings.
Okay.
I didn't know that we were going to be getting into different court cases and whatnot.
No problem. Go ahead with what, I didn't mean to get you off track. Go ahead with what you wanted to say.
For example, Your Honor, in United States versus Mueller, the court explained that, I do believe that's the citation just off the top of my head, that citizens were expected, when they were called for militia service, they were expected to bring the arms that they would typically keep at home for self-defense and hunting for militia service. That is the right that I'm seeking to vindicate first, and it seems like if we apply it how the government is asserting how the court is, it seems like the chicken's coming before the egg. Without the right to keep their arms for self-defense in the first instance, there would be no reason to ratify the Second Amendment. Does that make sense, Your Honor?
Yeah, I think I understand what you're saying there. So, so you're saying that the right to bear arms for self-defense or for hunting is separate and assumed in the Constitution, and that the Second Amendment is explicit about militia, and we wouldn't have had a Second Amendment if that baseline right to arms didn't exist.
That's correct. In other words, what I'm trying to say is I believe that the Second Amendment would actually be functionally equivalent to the Ninth Amendment. I think it's just a notification to government that the citizens are to bring their arms to practice and become well regulated in the ways of destroying our presumptively tyrannical federal government if it ever became tyrannical. And that is actually the right that the Second Amendment is protecting. The Supreme Court laid it out that because you can use both, you could use your right to keep and bear arms for militia service, for self-defense and hunting, but my interpretation of the Heller Court is that the Second Amendment doesn't preclude you from using your militia arms for that purpose, for self-defense and hunting too, but the more appropriate right to vindicate it would be under the substantive due process clause as far as Albright versus Oliver is concerned, because the majority made clear the argument that I've already stated, which is that the primary purpose, the explicit textual source of constitutional protection, preventing government from interfering with the armed citizens militia, is the Second Amendment. It's not explicit that it's actually for self-defense and hunting too. That's my entire argument on it.
Okay, I think I understand that, and I also, and so, and then from your briefing, it was your intent to drop the Second Amendment claims because of your position that this is not from the Second Amendment. This is, sorry, this is a substantive due process right.
If that interpretation was incorrect, that's when I moved to amend my complaint, that's effectively what I was probing for. That was my interpretation of it, and I was expecting the government to not agree to that if that interpretation was wrong. I was kind of thrown off when they agreed to it and then turned around and immediately filed a motion to dismiss the complaint on the same grounds that I asserted in my motion to amend, to file my second amended complaint.
Okay. And so, oh, go ahead.
That's all I was going to say about that, Your Honor.
Okay. And so, from your perspective, if the case were to go forward on your complaint, your argument is, as I understand, it's primarily a legal one, in the sense of there's not a lot of facts that you would need discovery on to support your position. Is that?
That's correct.
Okay. So from that perspective, whether the government moves to dismiss now or not, there's nothing additional that you would want to do to support your position. Is that a fair statement?
I believe so, Your Honor.
Okay.
I believe so, yes.
All right. Thank you. Anything else you want to add on your motion? Or, sorry, on your opposition to the motion?
Yes, Your Honor. I was confused as to the defendant's motion to dismiss. In their waiver argument, there's some citations and some events that concern me because it has a relation to another case that I have in court right now. And it was dealing with a judge disqualification, and there were some other unusual citations, and I believe that there's a possibility that these two cases are being mixed up by the defendants, Your Honor.
Okay.
I believe that there's some action being taken in this case that will impact the proceedings in the other case.
In the other case you have. Okay.
And I would just ask the court to admonish the defendants if that was their intent to stop doing that, please.
Okay, so I'm not familiar with your other case. Unless the other case you're talking about is the prior criminal case.
No, it's Harold Robinson versus Tad Meacham, ETL.
Okay.
And I cited it in my opposition to the defendant's motion to dismiss.
Okay. Okay, and then your concern was that they were trying to take actions in this case that would impact that case?
That's what it appears like, Your Honor.
Okay. And what effect are you concerned about it having?
My pro se status. My pro se status. There's a three-strike rule for pro se litigants.
Okay.
And if, for example, if this court were to dismiss my case pursuant to the judge's authority, the court's authority to dismiss my case by virtue of my IFP status, that could put a strike against my case, and I don't think that's actually, as I've argued, I don't think that they have the authority to do that. I don't think the rules provide for them to use the court's authority to dismiss my case pursuant to the IFP status.
Okay, so I can help clarify some of that. So under the statute that provides for the IFP status, that, as you noted, that gives the court the ability to sua sponte dismiss your case. And as you noted, that's the right of the court. But that is not, as I read the government's brief, that's not what they're moving under. They're moving under the rules of federal civil procedure. And under the rules of civil procedure, which is not a statute, but under the rules, a defendant can move to dismiss a complaint regardless of IFP status or not. And my understanding of the three strikes rule is that the issue there turns on, I think, the frivolous nature of the claim. And so if I don't make a finding with respect to that your claim's frivolous, if I just simply dismiss your case because it's not supported, that I don't think that that counts against you, but we'll let the government address that issue when they come back. Sorry.
Well, Your Honor, I'd just like to put him at ease. We don't consider his briefing frivolous at all, and in fact, thought he did a very good job. So to the extent that's a concern, not at all. We have no basis to argue frivolousness here.
Okay, so that's not, this would not be considered, they're not moving on that basis, and this would not be considered a strike for purposes of this three-strike rule, whether if you were not to prevail.
Okay.
And then as far as your other case, I have no, at least as of this time, I'm not attached to that case, so there would be nothing that I would have jurisdiction or authority to do in that case.
Okay, but okay, Your Honor. That
Does that help?
My understanding is the defendants wasn't moving pursuant to my IFP status. They were only moving pursuant to 12b-6. Right?
Correct.
Okay, that was all my concern.
Yeah, that's the only basis on their motion. All right, thank you. All right, and Mr. Glover.
Your Honor, if you have any questions or if you'd like me to, I guess, lay out our position on Heller, I'm happy to do so. Otherwise, we're happy to rest on the papers.
I guess maybe just, if you could just go back and address this issue on Heller, that would be great.
Yeah, Your Honor, I believe Mr. Robinson is drawing the militia point actually from Justice Breyer's dissent in Heller. And if you look either to Heller or to the 10th Circuit's opinion in Reese at 627 F. 3rd at 800, the court highlighted that the core purpose of the Second Amendment right was to allow, and then it's quoting Heller, law-abiding, responsible citizens to use firearms in defense of hearth and home. And so, we believe that the majority opinion in Heller, written by Justice Scalia, does focus on this is not merely about the militia. He has a historical debate with Justice Stevens on that point, but he emphasizes that hunting and self-defense are the core of the right, and we think the 10th Circuit has adopted that position and accepted that.
Okay. And so from your perspective, then that binds this court?
Yes, so that's why the right he's seeking to assert is there at the core of the Second Amendment.
Okay, and then I guess that takes care of, I think, the other issues in there. All right.
With no further questions?
No further questions at this time. Thank you. I'm going to take the matter under advisement. I will issue a report and recommendation which will lay out my findings on the motion and then recommend to the district judge the action to be taken. Each side will have 14 days after I issue that report and recommendation to object to that, and then the district judge can decide whether to invite further briefing or can decide just based on that objection. And then the district judge will make his determination about whether to adopt the recommendation or not. Anything else I can do for the parties at this time?
No, Your Honor. Thank you.
No, Your Honor.
All right. Thank you very much. We'll be in recess on this matter.